for lessons learned. Thank you for joining.
Yep. We're
Hello, everyone, and welcome to our event today. I'm just seeing some folks coming into the session now. Again, we'd like to say thank you to everyone for joining. It's what looks to be a very informative hour. We've got a very special guest to facilitate our event today. Over the past few weeks and into months, we've seen a lot of churn in the sector. And a lot of the focal point has come around to the activity that was at hand in respect to the impact of COVID-19. Then a few weeks later, we were able to get into an event and host another webinar on the financial impact through a survey that we sent out to the general population, to our members. And as I noted before, there's been a little bit more of a pivot into another focal point, that being lessons learned in our ramp up. Over the last few weeks, we've heard a lot of and seen a lot of activity with suppliers and companies getting into activity and getting back up to production. And a lot of those events that are taking place have side stories. And one of those is with respect to employment law. We do have on our session today, Michael Sherrard, who is a subject matter expert and counsel on employment law. We consider him a specialist. So thank you very much, Michael, for joining us today and facilitating some of the questions that I know are going to be coming your way. A little bit of housekeeping for everyone. If you turn on the chat function in the Zoom menu, you'll see a text box there. Please submit all of your questions and general comments into the chat box, only to the panel or panelists. You'll see an option there. The questions will be moderated between Shelley Fellows, Chair of Automate Canada, and myself. Thank you, Shelley. And before I turn it over, I would like to introduce Michael formally, and I would like to read a little bit of something to you. Recognized as one of Canada's leading employment and labor law lawyers by Chambers Global, Who's Who Legal, and Legal 500, Michael represents a wide variety of employers and sector associations, public and private. He is acclaimed for his strategic excellence and broad range of expertise, labor, employment, and construction labor relations. Michael has been involved in both Ontario and Canadian Bar Association committees and is the recipient of numerous awards. Michael is also widely published and frequently asked to chair international and national conferences on a variety of employment and labor law topics. It's a lot. So thank you once again, Michael. I'll turn it over to you now. If you'd like to go through a bit of you and start in on your presentation, that'd be wonderful. Thank you so much.
Great. Well, Mike, thank you very much for the introduction. Shelley as well. Looking forward to being able to go through some of the topics that I can't say are constant these days, because under COVID, it seems like constant is really change. And so what I hope to do today is take you through the following agenda, and we'll probably cut off. You've already seen a fair bit of information on CERB, the temp wage subsidy, both the 10% and the 75%. So we're really going to focus on the first 25 or so slides. There are a number of slides on the CERB wage subsidy. I'm going to leave those for you because they're pretty detailed, and I think you have a lot of information already. So my intention in the next 30 minutes or so is to try to cover all the different considerations that we look at when employers are trying to get people to return to work. And we're going to spend a little bit of time on the various protected statutory leaves, because many employers are having to navigate those, or at least be aware of those as you're working through your recalls and you're running into people who not necessarily want to come back to work right away, or are in situations that prevent them from coming back. So you'll want to have a fairly good working knowledge of those areas. So we'll take a little bit of time today on those. And then also we have people who are fairly concerned with respect to their own health and safety, whether it relates to the workplace you're asking them to come back into, or it could relate to simply the transportation issues that they see or fear in terms of how they get from their home to your work location. And many of you are already into the ramp up, if not fully running. And I want to try to cover some of those off. And then some of the strategies that many of our clients and employers around both Ontario and in the rest of the country are looking at with respect to the use of temporary layoffs, voluntarily and agreed to leaves. And then unfortunately, there are some of these layoffs are turning into terminations, and certainly some of the people who aren't prepared to come to work, you may actually get to a point where there might be a termination. And we want to talk through that process and give you some guidance and some considerations around risk mitigation as well. So with that, I'm going to dive in, and as Mike and Shelley said, they'll field questions, and my intention is to go through the slides in about 30 minutes so that we leave lots of time for questions, and I'll do my best to address those as we go. So the first thing that has come up is, all of you are probably already aware, but when our Premier declared that state of emergency, and I'm paraphrasing as opposed to the actual act, one of the things that happened was the emergency leave that already is in the Employment Standards Act. And remember, the Employment Standards Act is what guides all of us with respect to minimum entitlements. You may have policies that exceed those entitlements or contracts that exceed those entitlements, but I'm going to try to talk to really are just these basic entitlements, and you'll find them all in the Ontario Employment Standards Act. This emergency leave is actually already in our act, but it was triggered by our Premier quite a while ago now. And what it essentially does is it allows somebody to be off work and to have their job protected if the rationale for why they're off work fits within the emergency leave section. And so let's talk about that just briefly. We know that this is retroactive to January 25th. Where it says will remain in place indefinitely, you really look to Premier Ford and the government's announcements as it relates to the continuing state of emergency. We know today, I think, or sometime earlier this week, I should say, that state of emergency was extended to June the 9th. So this leave itself gives employees who fit within it protection, at least from not being affected negatively in an employment relationship by their use of this leave if they fit in it. You'll see that there are a variety of circumstances under emergency leave. The first one, all of you have seen this before, if an employee is in isolation or quarantine in accordance with public health information. So they may be actually self-quarantining because they've identified they've been in contact with, as an example, a presumptive COVID-19 case or a positive case. The one that's coming up very, very often recently for all of us to try to navigate is somebody who is at home and because of the closures of schools and daycares, they're in a position where they have to be at home to care for their children. And that's caused a fair bit of angst across our province in terms of trying to find a way to balance those family needs juxtaposed against employers who want employees back to work. And then it may also be because the employer themselves have directed somebody not to come to work due to a concern around COVID. And that's usually when there's been a presumptive or a more likely a positive test, and you've got a shift, a department, a work area where when you do your contact tracing, you find there's a shift of people that were in contact within a time frame, and it requires you, or the strategy has been that group is now asked to go self-isolate for 14 days. So that may cover it as well. And the other thing to watch out for is on the emergency leave, take a look in the Act, because the Act actually has a list of those who the employee might be providing care for that excuses them from having to come to work. And what we found was when we looked at this, it's quite a broad scope of people. It included aunts and uncles. It included the normal, those spouse, children, grandparents. But take a look at the list because it is actually quite broad. The other issue that has become a bit challenging for some employers is in the emergency leave section, it actually says the employer is not permitted to require a medical note, but may ask for other evidence reasonable in the circumstances. Reasonable in the circumstances today likely is not asking somebody to go see a medical official. What we've had for most people is there's a presumption with employers that daycares are closed, schools are closed. Sometimes it's as simple as an employee attestation. Somebody has been stuck outside of the country. And those kind of circumstances are certainly shrinking now, but certainly in the first part of this pandemic, that was happening a lot. And then the other thing to pay attention to or to watch for is, for those of you who have collective agreements, many of them actually have leave provisions, and those serve for guidance, because so far, COVID's not intruding and changing your collective agreement unless there's something that's lower than an employment standard or lower than something that the government has ordered in one of these regulations. And so what we tried to do here is the employment standards has a variety of leaves. It's got family caregiver leave, family medical leave, critical illness leave. It also has a number of others. And so we tried to group them together with where an employer can ask for a medical certificate versus where they are not able to ask for the medical certificate, but are able to look for something reasonable in the circumstances. And we're hoping that slide basically speaks for itself in terms of grouping these, but we picked the specific leaves that are under the Employment Standards Act. You'll see most of them all in section 49 and section 50 of the Act, if you're looking to try to look into those in detail. So let's get into the meat of this. Many of us have unfortunately had to work through this. What do we do if an employer refuses to return to work? And the first thing you're trying to do is you're trying to figure out, is the rationale for why they don't want to return one of these protected grounds of leave? And so when they request, they still may be required to return to work, but you have to assess the rationale for their leave first. So first one, if somebody's off sick or away from work, caring for a sick relative, those kind of situations traditionally are going to be covered. There's a sick leave provision in the Employment Standards Act. It's unpaid, but it's there, so beware of that. And then when it comes to illness leave, leave for the purposes of caring for a sick relative, it's likely that that's going to get covered under one of those grounds. So take a look through 49 and just see if they fit. you want to be very careful there, because at the end of the day, the employer can't negatively impact that employee for missing work due to one of those protected leaves. Here are some, and I'm just going to whip through them quickly. If you look at the very first one, family medical leave, watch for that one. It says it's for somebody who is supporting a family member suffering from a serious medical condition or at significant risk of death. And there's a time frame around this. This is 49.1. Again, somebody might fit within this. So when you're trying to understand why they're not coming back to work, listen to see whether or not they're actually fitting into one of these. Family caregiver leave, a little bit different. It's supporting a family member suffering from a serious illness. So you're talking about somebody who has a serious medical condition, different than medical leave above, no requirement for that significant risk of death. Sounds, very subtle, but it's significant. And the period of time that's protected is different. See the 28 weeks versus the 8 weeks. The other thing to notice is the emergency leave we've already talked about versus, for example, family caregiver leave. If you look into the Act, you'll find family caregiver leave has a much smaller scope of who your employee may or not be taking care of and fit under this protected leave. So you'll want to look at the scope in, for example, family caregiver leave 49.3 of the Act. Then we get to critical illness leave, which could come up under this one. And the baseline on this one, the way the Act reads is it says an employee, the baseline, who is caring for somebody whose baseline state of health has significantly changed and whose life is at risk because of this illness or injury. So you want to watch for that one. It may come up as well. Again, it's a protected ground of leave if an employee fits within that. And then finally, the sick leave one, which is fairly straightforward. And you'll notice that it's unpaid, it's got daily limitations on it, but you will want to see, again, we just wanted to put these up quickly so that you were at least aware they were there. Now, if there's no available leave and somebody still refuses to return to work, we've got to try to figure out, well, on what basis? So if they have some other medical issue, our recommendation is to engage in that conversation and potentially ask for medical documentation if it's not fitting in any of the protected leaves or the ones that restrict your ability to ask for medical documentation. If it's simply they want to stay at home, then our job is to try to understand as best we can, what's the rationale for that? Is somebody suffering from an anxiety disorder, or is there a specific concern of workplace safety for their basis of not returning to work? And we're going to try to carry that through on these next slides. So if they have a specific concern about workplace safety, all of you know, occupational health and safety protects an employee who refuses to come to work on a bona fide reason, for a bona fide reason, usually relating to machinery or equipment, but we're seeing now the interpretation is clearly covering the circumstance of COVID-19 as well. So the practical way to deal with this from our perspective is to engage with the employee, to actually talk to them about the kinds of things you've done to ensure as best as you can their health and safety in your workplace. So that's everything from having a COVID-19 policy and the elements of it, what your cleansing and sanitation protocols are, what you're asking of people for social distancing. When social distancing is not possible, what you're doing by way of barriers or masks. Remember, for a lot of this, you want to be continually looking at public health updates, because if you look to their updates on what is reasonable and necessary for an employer to do to keep their workplace safe, you're usually going to be well equipped to address that employee's concern. Now, remember, we're saying, I'm making the assumption in this slide, they've already said it's due to the workplace as opposed to anything else. So gather the information from the employee. If you have a joint health and safety committee, you want to engage that joint health and safety committee, because this may come up repeated and you may already be into processing a number of these concerns. I traditionally want to make sure I've nailed down what the employee is concerned about. If I can get them to email me as an example so I have something in writing, that's also helpful. I'm then going to move and engage to my joint health and safety committee, and I'm going to ask them to investigate with me. And then I'm also, with the help of the joint health and safety, I'm going to try to illustrate to the employee what we, the employer, have done to address the concerns they've raised. If after I've done that, the employee is still refusing to come to work, then I'm now in a position where I traditionally need to report it to the MOL. And the MOL, we've seen various examples of this over the last 6 weeks. They will investigate the concern. They may do it remotely. So you may be getting interviewed on the phone. You may be providing them with your new policies on COVID and your procedures that you've implemented by way of email to that MOL officer. But that MOL person will issue an order or confirm there's no need for an order. And you know that if there's no need for an order, what they're telling you is the workplace is safe. I don't find there to be a bona fide concern with respect to what this employee has raised. And in those situations, just before we move into the tools to respond, where you're left at that point is the employee is now required to come to work. If they continue to refuse, you've got multiple ways of dealing with it, but you can stiffly, and I mean it that way, deal with it as a disciplinary manner. So think of it as potential discipline, or is there something else I can do if I, the employer, want to consensually work on that? Or do I have a collective agreement that actually might dictate their requirement to return to work within a certain amount of days of being recalled? And if they fail to do it, most collective agreements say they are deemed to be terminated and or they lose their seniority. Okay, so let's jump into some of these. So these are some of the tools that many of you are using. If you've got somebody who is not eligible under the protected leaves that we whip through fairly quickly, they can still remain at home if you agree and you leave them on what's called a discretionary leave of absence. Again, that's the agreement between you, the employer, and the employee. You might, subject to your employment headcount requirements, and remember, we've still got lots of people that some of their jobs allow them to work from home. Many jobs can't be done from home, obviously, in many of our organizations, and we actually need them physically back to work. But where you can, some of us are soliciting volunteers for layoff before we require people to come back. My only hint on that one is to watch out, make sure it's temporary because your need may change. And determine how many employees you actually need in your various roles, and be careful to try to administer your recall and those who you're prepared to let stay on layoff on a fair basis. So you need some protocols so that you can illustrate to your employee population why somebody's being left at home or not, subject to their context. You all know that the Employment Standards Act says we can temporarily lay off an employee for up to 13 weeks in a consecutive 20-week period without it being a deemed termination. So that's the, again, minimum standard. I'm going to talk about constructive dismissal in a few secs. We also know that you can extend the 13 weeks to 35 and 52 if you keep in place, and the most frequent one we're seeing in Ontario right now is the continuation of benefits. Many employers have decided to continue benefits so that they keep this temporary period of layoff so as to avoid any kind of deemed termination. And I'm going to try to talk about that next. So you know that if that layoff extends past 13, or if you've got yourself into that 35 and 52, if it extends past 35, an employee might take a position that they've been deemed to be terminated, and now employment standards minimums for termination pay, potentially severance pay, kick in as well. And you want to watch for those because many of you are watching cash liquidity and you don't want to be surprised by these. There's a rumor mill in Ontario, and I want to be very careful to say this. This is a rumor mill only. We haven't seen it yet, that Premier Ford's government might be looking at putting in some kind of legislative change that says the weeks of layoff during this pandemic from a certain period of time, i.e. March 1st or March 15th maybe, shall not be counted for the purposes of temporary layoffs triggering deemed terminations. Again, it's rumor mill. Please don't quote me as, there's a new law out there. It's just rumor mill, but keep an eye out for it because many employers are getting close to that 13 weeks based upon how long we've been in this pandemic. But keep abreast, and it's good advice for everybody. There's a lot of work to be done to keep in tune with all the various changes that our government is making, whether it's applicable to you or not applicable to you. I'll give you a minor example really quickly. We've seen the Ford government recently come out with a worker can only go and work in one location as an example. We've seen that extended into, I think somebody's raised a question earlier about extended into the greenhouse field as well. And it's one thing to understand that the quote employee can't work in 2 work locations, but what about all those people who service these variety of places, including, and I know it doesn't apply to your audience, but we're all reading it, long-term care, retirement homes. it's pretty clear that the employee can only work in one location. It would appear not to be caught, though, for people that are service or maintenance folks who might actually work from one employer to the next employer. It's not even their employer, it's actually a commercial relationship. So the way the legislation looks right now, it's very focused on employee as opposed to those who might be servicing. So I just commend you to talk with your lawyers and see, does this situation impact you or not as it relates to people who move from one employer to another to actually service. All right, just trying to keep aware of the time as well. You'll notice that if you do temporarily lay people off, some of you have already done this. Some of you may be still thinking about it because we're getting to a point where if the pandemic continues, your level of work isn't rising like you would have hoped it to have risen. And so some of us are actually looking at temporary layoffs today that we hadn't had to yet. In those situations, the Act doesn't say anything or give us any requirement in terms of what's in that layoff notice. Our advice, best practice is you do the layoff in advance, the notice of the layoff in advance if you can. We won't be able to employ you next week. Give them as much notice as possible. We like to do it in writing if possible. We like to indicate it's temporary if possible. If I can, I actually want to indicate a date of return. If I can't indicate a date of return, I also want to think about how we're going to keep in contact. I want to issue a record of employment in a timely manner. And you can see in this situation, the record of employment typically is coded as A, and you know there's a guide in the record of employment with respect to how you might code it. We've heard lots of writing with respect to constructive dismissals, and the essence of what they've said is, regardless of the Employment Standards Act, if an employer doesn't have the right to temporarily lay somebody off in the employment contract or in their employment policies, somebody might assert that your unilateral layoff of that person, even on a temporary basis, is a constructive dismissal. You want to worry about that or at least be cognizant of it because that can lead to a claim for wrongful dismissal damages, which typically will exceed the Employment Standards Act termination and severance pay. Now, we're going to give you some risk mitigation things to consider when you do this, because I can temporarily lay off people, avoid a constructive dismissal if I have their consent. So it sounds odd, but there's a very simple risk mitigation strategy to avoid the risk of constructive dismissal. The other thing we think is that if you were, for example, in an industry or become in an industry that the government regulations force you to stop working or to shrink, you might point to that as a defense to a constructive dismissal claim of somebody who you've laid off due to that order to close or to shrink your operation. And again, the other part of this is employees have a duty to mitigate in this area, so they have to watch too in terms of what to do or not do if you temporarily lay them off. Risk mitigation for us, try to define the temporary period of time if you can, secure their agreement if you can, and if you get a claim, and that's the other thing, we were worried that we were going to see lots of constructive dismissal claims. I can tell you our experience over the last 4 weeks is people are talking them, but claims don't seem to be materializing. And I think that's at least partially because many employees are hopeful that they'll be recalled back to work. And they really don't want to sever the relationship by alleging a constructive dismissal and suing their employer. So that doesn't mean breach the rules, but consider, can I get their agreement? Can I do it temporarily? Other things to think about under constructive dismissal, many of us have company leaders who are agreeing to shrink their incomes. So the leader of the company says, I'm not going to take an income, or I'm going to reduce my income by 20%. A lot of those are a lot of strategies around cash flow have come up, and we've seen across the board or across a classification or an executive classification in an employer where they've agreed to take a reduction. Again, we've got employee agreement, and even if you do it unilaterally, I actually think employees have to be wary of making a claim if your unilateral reduction is in that 10 to 15% range. So even where, and remember, this is still a live issue, so you've reduced their income by 15%, and you've also reduced the amount of work you're requiring of them, that this issue is still live. The one thing I would ask you to consider, many of our clients have been very successful with respect to EI work share programs where they take a defined unit in their workplace. Everybody agrees that they're going to go down to, a 24-hour work week as opposed to 40. and they make an application through EI, Workshare federally, and they get employment insurance earnings for the amount of time they've reduced their work week. So it doesn't get them full, but gets them much closer, and it's worked quite well for a number of employers. Okay, so terminations, really quick advice. Careful in terms of if you actually get to termination. So I'm not talking about work refusals. I'm just talking about if you have to shrink your workforce and you're beyond simply temporary layoffs, make sure your selection process is defensible. Watch out for somebody being able to allege after the fact that it looks like you terminated all the 63-year-olds, to pick an age discrimination piece. Watch for those as you go through. We also have duties to accommodate that still continue in the pandemic. Be a little careful with respect to how you're engaging with those folks who you already owe a duty to accommodate due to a disability. You want to not fall offside there. Human rights claims are still out there. Look at your employment agreements, because many of you have enforceable termination clauses and they help. Some of you don't. So you want to know that ahead of time. And then again, you've got two things to consider. Not just the Employment Standards Act that I've talked about, termination and severance pay, but potentially common law entitlements subject to your own documentation. And I really commend you to talk to your lawyers to check out your language before you trigger these. Common law entitlements are more expensive than the Employment Standards Act. All of you know that already, usually based upon age, the role somebody's in, how long they've been with you, how much you pay them. It's really looking at how long will it take to find comparable employment. Here's where I'm not going to be able to answer one of the questions for sure. During the pandemic, does that change what the common law notice period is? And I think, frankly, you're going to hear employers say, from a cash liquidity perspective, it should be shrinking. From an employee perspective, you're going to hear the plaintiff lawyers say, well, no, I can't find a job in this time frame, and therefore it should be expanded. We have no court direction yet on something like this for guidance, so I apologize, but that's one of the variables we're left with. Just be aware it's out there, though. I do commend people to think about, if you can get a release, much better getting a release if you get that the amount of notice you're going to provide to somebody is at least within your expectation and they're prepared to sign off on a release. Think about that as a method to avoid litigation, assuming you can get the employee's agreement. I usually always want to try to get a release. So the employer government assistance. I also want to talk just briefly. There have been a number of questions recently around vacations, and then I'm going to stop there and open it up for questions. The first question I've heard a lot of is, can an employer require an employee to take a vacation while they're working from home, as an example? And the short answer is, absent there being something that stops you in a collective agreement or in your employment contract, you, the employer, can force the scheduling of a vacation. Be careful, though. Employment Standards Act does say, well, the employer can force the scheduling of that. It must be in a full week period unless you've got the consent agreement of the employee. So I can force a full 1 week vacation because a lot of us are worried about when we get up and running or we're busier, do I have an entire employee population who's got vacation entitlement normally spread over a year, now in the back 6 months of the year? So lots of us are working through strategies. I always start with take a reasonable approach with your employees, explain the issue, and see if they'll consent to it. But the short answer is you can actually force it if you wish to. If somebody's on layoff, can you count the time on layoff as vacation? Short answer is no, you can't do that. So you might, for example, if you want to exhaust some of your vacation obligations, you might think as you call people back, call them back early with maybe that first week that they're called back being vacation time. Again, it's forcible. You can do that, but watch out for that one piece that says we have to make sure that it's full weeks. I think, Mike and Shelley, I'm probably over time. I probably should stop there and see if I can't address questions, if that makes sense to you both.
Well, absolutely. I mean, thank you, Michael. So far, I've been watching the screen and making notes for myself because you had a lot of really good information. Let's see, maybe we'll leave the screen where it's at, or if you want to stop sharing your presentation.
Yeah, I'll stop sharing. Maybe that'll work.
Okay. And so you'll notice that there's someone absent from our screen. Unfortunately, Mike had to step away to take care of some business, so he apologizes, but he will return if he can before the end of the call. So what that means is you're stuck with me.
That works.
So one of the things that I was making a note of, so right off the bat, you addressed a question that we received in advance of today, and there were some people who sent in questions in advance of today's seminar. But it was also something that, we discussed initially, and that was the issues around what about if an employee refuses to come back to the workplace. So you made a recommendation as to one of the steps for an employer to take, and that is to contact the Ministry of Labor. So what about the circumstance where employers are a little allergic to contacting the Ministry of Labor?
That's a very good way to put it. So I think maybe I back up, and the first things and I may have gone too quickly in that area, so let me take another shot given the opportunity. First thing I want to do is engage with the employee.
Right.
Because if I engage with the employee, especially, let's assume I want these people back. I need my talent back in my workplace. I'd say the first thing I do is engage with the employee to make sure I can suss out what their real worry is or their basis for their refusal to come back.
Mm-hmm.
And then I try to, in a pointed manner, demonstrate the kinds of things I've done to address that concern. I've actually seen employers do some pretty extraordinary things. I've seen employers that are thirsty for talent to actually do incentive payments, almost like thinking about a carrot versus a stick approach.
Mm-hmm.
And we have had some people be very successful in getting more people back to work by increasing their pay.
Mm-hmm.
I saw one employer last week who did something quite novel. It's very context driven. He said, I'm going to pay my people to come to work, but I'm also going to pay them to stay off transit. And I'm not sure that would be my advice, frankly, but it worked in his context. In his context, he said, I'm going to pay for those who will ride share because they work together anyways, but I'm actually going to contribute to the circumstance that somebody will actually volunteer to pick people up.
Mm-hmm.
I saw another employer actually subsidize Uber, believe it or not. And I also saw an employer who decided they would subsidize parking payments. Again, context specific. Can you do it within your margins? Is there a cost benefit analysis?
Mm-hmm.
So I actually have a great degree of empathy for the allergic to MOL approach. And certainly I empathize and I understand. They've been quite constructive. And sometimes the engagement with the MOL, remember, it's already after I've tried to reason. I've already used my internal committee, and my internal committee is usually quite useful too, because now I'm using a peer group that can help. And frankly, maybe I've made improvements as I go through the process. So a bit long-winded, but I think there are lots of things to do before that MOL call.
Yes. Yeah. Yep. Absolutely. Okay. Good. Thank you.
And by the way, when you get that refusal, if you're not going, I'm not in my head, you've gone to your Joint Health and Safety Committee. They say the workplace is safe. There is no bona fide complaint.
Mm-hmm.
You're not required to call the MOL now, but you are required to call the MOL if you're going to go to the stick approach with the employee vis-a-vis their continuing refusal.
Mm-hmm. Mm-hmm. Now, and this one that we just received this morning. So this maybe is a little specific in terms of the situation, but the scenario is that the employee actually went home before the state of emergency was declared, or the date to which it's retroactive. I think you said January 25th.
That's correct, yes.
Right?
On the emergency leave piece.
Yes. So apparently this employee is planning on staying home until a vaccine is in place. And if there's a second wave, I guess even post-vaccine, that employee intends to go home again. However, that job is an essential job in that workplace. Many of the companies around here are, we know from the survey, about 2/3 of our respondents were 50 people or less. So many of the workplaces are smaller workplaces, and every single employee is vital to the operation of the business. Is there anything different in your recommendations that you would consider in that case?
A couple of things. Let's assume we've gone through all those steps to try to understand or rationalize with the employee, and they've still said, thanks, no thanks, until there's a vaccine, I'm staying at home.
Mm-hmm.
If they haven't raised with you how they could fit in any of those statutorily protected leaves,
Right.
and you have a safe workplace from the perspective of your joint health and safety committee and or maybe the MOL. Now that employee's in a position where they can be seen to have resigned,
Mhm.
you, the employer, might exercise your discretion to give them a leave of absence,
Mm.
or you might put them on notice that it's your intention, unfortunately, to terminate their employment unless they are back to work. Now,
Right.
I usually give them lots of notice, and I try to decide. Sometimes people, there's that old phrase, right? If there's no issue, and I apologize for, I don't mean this to an employee, but let sleeping dogs lie. Some
Mhm.
people may say it's okay to leave that person out there because I'm going to go find another way to get this essential job done.
Right.
What I run into all the time is the employer who says, how long do I have to protect that job for? That seems to be the magical question. My usual answer is go fill your need. Assuming you've done all these processes, go fill your need, find that talent if you can find it, but
Mhm.
illustrate to that employee that their job is now at risk. Where we
Mhm.
don't want to be is we don't talk and communicate effectively with the employee, and 6 months from now they say, oh, okay, I want to come back. And you say, sorry, I don't have a job for you. You want to communicate to them your intention and the process you're going to follow. I'm not sure it would be deemed to be reasonable for somebody to say, I'm not coming back until there's a vaccine. Like, I'd love to say there's a vaccine tomorrow, but you know more than I do as we all watch the news in terms of when we might have an effective vaccine, let alone anybody trying the trials.
Mhm. Yeah. 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 We don't know, do we? Okay. Thank you. Maybe just one more extension on our list of questions in that vein of thought. So the scenario where the employees have been sent to home to work from home. So they haven't been sent home on layoff or furlough, but been sent home to work from home. And now we're all opening back up again and bringing people back in. They've been called back to the workplace. However, an employee refuses to come back to the workplace to work. They cite concerns about their health and risk to themselves. Are the best steps for an employer in that situation?
I think, frankly, the first one, and it may be already obvious. I mean, the first one I get into is it possible to let them still work from home?
Mm,
And I think many of us are going through that new thought process that many of us thought we had to have everybody in the same spot, all of us looking at each other and being close enough to each other. So
mhm,
many employers are actually looking at job classifications that can actually function effectively from home. So that's the first piece.
mhm,
Let's assume you've concluded that no, I can't do that. Now we go into the process that we've talked about a bit already. What is the basis for their fear or desire not to return to work?
mhm,
Because it could be something as simple as I got young kids and I'm the caregiver. So again, we go through that from a process perspective. Are they on a protected leave? Is it fear of health and safety or lack thereof in my workplace? And I
mhm,
go through the work refusal pieces. And then again, I'm into, again, unfortunately, trying to decide whether I'm going to actually separate employment. And remember, most employers want to take, in this position, we want to take a position that really what the person's doing is resigning
mhm,
as opposed to you're terminating them.
mhm,
Different coding in the ROE. And
mhm,
remember, if somebody resigns or quits, they're actually not entitled to a number of these government subsidies. And so, not to be unfair, but I make that pretty clear to the employee who's balking at coming back to work. And so
mhm.
that there's no surprise when I mark resignation. Now, it's
Right.
not foolproof. We have examples where we've gone through all these steps and somebody still claims that what you've effectively done is terminated their employment.
Mhm,
And so there's a risk. And so you want to engage counsel, I think, or human resource professionals each time to check out your risk because you may be able to take a step that risk mitigates.
okay.
But I think it's quite the same process. But I think many employers today, I'll be surprised if we don't have a significant population in Ontario and Canada who
Mhm,
actually work out of their home from now on.
mhm,
Sounds extraordinary. I wouldn't have said that 6 months ago, obviously, but I think that might be our new reality in some positions.
mhm. And we are hearing about workplaces that have declared, effective immediately, we will be switching, um, we will be supporting only working from home, right? We won't have a
Yes.
physical office space.
Yeah.
Not feasible for many of, our audience today, but we certainly have heard that. Okay, I'm going to switch gears.
Just quickly, what I've seen in your audience, really easy strategies. I've seen people go to 2 shifts instead of a single shift.
Mhm.
Just different ways to space people out. So I've seen some very creative solutions that way to try to address employee issues. And frankly, the employees have come up with resolutions themselves sometimes.
Yeah. Okay. So I started to say I'm going to switch gears on you because I'm
Sure.
interested in your thought, as is a member of our audience today, on the balloon that's been floated about 10 paid sick days by the federal government.
Yes. My thought. I would say first, I'm quite worried about it.
Mm.
I don't think the federal government has the jurisdiction themselves to enforce upon a provincially regulated employer the obligation to actually provide 10 paid days. So that's the first thing. That means that the federal government has to engage with each provincial government. I think the rumor mill is that this really came out of Premier Horgan in British Columbia, and it was his motivation to try to see. And then there sounds like there might have been a trade-off between the NDP and our federal Liberals, potentially. I worry about it because this province has already lived through, you may remember Bill 148 under the Liberals, all of the submissions, the independent study by former Justice John Murray and Michael Mitchell, former arbitrator. They spent a long time consulting all over this province and wrote a report. And then we saw legislation that did not have 10 unpaid days in it. And then what we saw next was Bill 47. The Conservatives came in and removed a lot of the implementation by Bill 148. And I think it would be very challenging for our employer population now all of a sudden to be told they now have a new employment standards provision, and now it's 10 unpaid days. So I'd say who's going to pay for it? Now, some of your members, frankly, may already have a policy in place. Some of you already may have paid sick days in place that accrue over a period of time. So the government's going to have that in mind. I think in your sector, it might have less impact than it will have on the service sector, restaurants, hotels, that area. So long-winded answer, but I leave you with very concerned, but the jury's out. We really haven't seen our provincial premier pick that up and start talking about it yet. At least I haven't seen it.
Yeah. Yes. And I know there's a lot of attention on that. Okay. Go back to another scenario. We have another scenario here. And it's a situation that's not uncommon down here. Employer with an employee whose spouse works in the US. And so the spouse is an essential worker, not in the healthcare sector. I was just checking the question here, not in the healthcare sector, but an essential worker who has been traveling between Windsor and Detroit to perform their job. Now, the spouse, the worker who's been going over to the US, has not been advised that they need to quarantine at the border. And I believe there's like an exemption for essential workers with that criteria, because otherwise someone coming into Canada would be advised that they need to quarantine for 2 weeks. They have not been advised of that. However, could that employee be considered a health and safety risk in the workplace? And if so, how best to deal with that?
So I think I'd start with saying that's a tricky one. It's not a simple answer, but let me take a shot.
Okay.
Let's assume you unilaterally hold that employee out of the workplace due to that circumstance. I think you have to at least start by worrying about, you might even get, believe it or not, you might get a human rights complaint based upon marital status. I've held you out of the workplace because. Now, that's not where I stop, because we move right over to health and safety. And I always believe, I don't want to trample on human rights, so don't take my answer to say that. First, be aware of that, and now let's look at health and safety. And I think under the health and safety side, I think our Ontario government COVID-19 self-assessment tool says something like this. Anyone who is in close contact with an individual who has traveled outside of Canada should be tested for COVID-19, even absent symptoms. So if I'm actually paraphrasing that correctly, seems to suggest to me that public health deems there to be a heightened health and safety risk in the circumstance you just described. And so if that's the case, I think you have to think about measures to at minimum to minimize exposure.
Mhm.
Right? So the question might be, are you and your husband self-isolating? When you two come and go from the household, are you actually self-isolating? And believe it or not, I've seen a number of trucking companies that are moving back and forth,
Yeah.
actually requiring their workers to attest that they are self-isolating. So I'm actually seeing spouses live in different parts of the house, believe it or not,
Wow.
watch how they do food, the whole 9 yards. So that might be the first practical one. Are you
Mhm.
self-isolating? If you're not, can you demonstrate to me that you're self-isolating? I'd go through all of those processes first before I unilaterally held somebody out of the workplace.
Right. Okay, that's excellent. I mean, and again, it's not unusual in Windsor, Essex, to have
Sure.
households where one spouse is working in the U.S. You know, there's been a lot of visibility on the healthcare workers recently,
Yes.
but there's other people who are
Yeah.
crossing that border.
And it probably goes without saying, but many of us have screening tools as well,
Yeah.
right? So we've had everything from taking temperatures to other questionnaires. Like I never say taking temperature is enough by itself. It might
Mhm.
be part of an overall screening process when you bring employees into the workplace.
Mhm.
But you'd be saying to that spouse, um, self-awareness and watching for symptoms, and certainly if symptoms develop,
Mhm.
we'd want you not to come to the workplace.
Mhm. Okay. All right. So I have another kind of specific question that's come here. And it relates to, I guess, really the measures that we're taking to help manage our costs. So, you know, we saw that through our survey. We saw the number of employees who were put on temporary layoffs really spiked at the beginning of April, and has, you know, declined since then. But employees have been furloughed, and, you know, different steps have been taken. So this particular question relates to not a layoff, not a termination, not a leave or leave of absence, but a shift from full-time employee to contract employee. So, and I'm assuming with a reduction in hours that would go along with that. What, you know, what is important to consider if that kind of move is being contemplated?
So let me give you let me add some facts potentially. So
Mhm.
let's assume you've got everybody working on a 40-hour work week and you've made a decision that I really only have 24 hours a week for everybody.
Right.
If you're in that situation, then I really commend you to look to the federal EI work sharing program.
Mm-hmm.
And there are some catches in it. It's a fairly straightforward process. Service Canada has a great educational piece on how to fill out the forms. The catch for us is I think it says the identified group all have to agree to participate.
Mm-hmm.
But the sales point to that identified group is, so I'm going to pay you 24 hours. You're losing 16 hours, but I know I can get an EI makeup for a portion of that, right? And so that's the first strategy I would think about. If we're talking about individual persons, again, I want to try to seek their agreement, as we talked about earlier, because if you move somebody unilaterally from 40 hours down to 24, if my math is right, they're now at about 60% of their income, give or take.
Mm-hmm.
If that was consistent, go forward. And I think at 60% of their income, unless you had a, a right to do that, either in an employment agreement or in a policy, you're at least at risk of getting a constructive dismissal kind of claim. And so you have to at least keep that risk in mind. You may say, look, based upon my volume of work and my cash liquidity,
Mm-hmm.
that's my only choice.
Mm-hmm.
So while I commend lots of employers to look at that 40 down to 30 or 40 down to 24, so you're able to retain all your talent with the
Right.
hope that we're all going to come out of this with an increased employment need. Some employers are actually saying, okay, I can't afford the risk of these constructive dismissal claims. I've already sought and I can't get the employee agreement on any of this. Then I've seen some employers say, okay, I'm going to work my 40 hours, but I'm going to work it with 8 people as opposed to 12.
Right.
And that means I'm actually going to terminate the relationship with 4 of the people, or I'm going to temporarily lay off those 4 with the hope that I can bring them back at some point. I don't say that's my first choice by any stretch, but you could do that to at least reduce your risk of having 12 people assert constructive dismissal as opposed to just those 4 in terms of achieving your reduction in hours.
Okay, thank you. We've got a couple more questions here, and we've got just about 7 minutes before 1 o'clock.
Okay.
So I'm going to remind everybody, if they do have some questions, please send them in. If we don't have an opportunity to address them with Michael today, we'll do our best to get information to you after today's webinar. Okay, so another scenario.
Okay.
We had employees who were on temporary layoff prior to COVID. We extended that layoff through the beginning of COVID, and now we're coming up to 35 weeks. What do we do? What do we do?
What do we do? So if you were listening to our Prime Minister, our Prime Minister would say, bring them back to work, apply for CEWS, and, you know, get that 75% to a max of. Because remember, a number of those federal moves have been trying to motivate us employers to bring people off the EI system or to prevent them from going on to the EI system. That's not, you know, that won't work for everybody, but that's the first place I'd actually look. Could I qualify under CEWS? And that's the back part that we didn't cover, but I think you covered about a month ago. I would take a serious look at that, because that may afford you a chance to bring some people back.
Okay.
And look, remember, we've seen employers bring people back and bring them back and pay them so as to avoid triggering the termination payment, and even leave them at home while you're paying them through at least, you know, 80, I think it's 80% to them, you know, to the, if we get into the dollar amounts, I think it's like $847 a week. But I would actually look at that as my first strategy to see, can I shrink that population and figuratively bring them back to work and use CEWS to reduce my cash flow.
So either to support bringing them back into the workplace or put them on furlough. This particular scenario, the company really doesn't have the work to support them in the workplace. So the next opportunity to look at would be CEWS to support.
Yeah, because I think CEWS may present a cash flow out for you that is tremendously different than the termination costs. It's pretty controversial to do it this way, but it's certainly a strategy to consider at least. And we have seen a number of employers do it to interrupt that 35-week piece and to attempt to, you know, the first thought is you're attempting to maintain the employment relationship, but you're finding a different way to avoid termination as well at the same time. Not foolproof by any stretch, but it's at least one strategy.
Can the same employer have CEWS and work share arrangements?
I'm not positive on that. I think that's, I would have guessed, and I mean it this way, I would have guessed that no, you probably can't do both, but I haven't looked at that one specifically. I'm happy to do that and follow up with you as well.
Okay. And then one question that just came in, and again, that cross-border issue. So they have a couple of employees in their workplace who have spouses who work across the border in healthcare, and actually here locally, so domestically in healthcare. So healthcare workers as spouses, other employees are worried about the risk of working with those, you know, the individuals who have spouses in healthcare.
Yeah, so again, it's a tricky issue, but I think I really go back to what we've already covered earlier. You want to talk to those employees who at least potentially have exposure, because we do have guidance from public health that gives us some heightened awareness of people traveling back from the US or being in healthcare potentially as well. There are a number of steps that you can take to try to self-isolate, and I think you have to talk to your employees about whether or not that's viable. And if it's not viable, you may hold them out of the workplace. And if you hold them out of the workplace, there are risks inherent in that. But again, if we think human rights versus health and safety, I really do lean toward complying with health and safety and taking care of, watching out for the health and safety of everyone. And sometimes at the educated risk of potentially falling afoul of marital status, as an example.
Right. So tread carefully.
I think that's the better answer in much more efficiently than I did.
Well, and you know, we don't want to initiate what is happening in the greenhouse sector right now regionally with the breakouts that are clustered at some of
Yes.
the facilities, and then, got the attention of the provincial government, and orders were issued about restricting the movement. You addressed it in your presentation. That would be very difficult for a number of companies in our membership to deal with. So that would be tough. Okay, one last question to close this out, because we got a couple minutes. What about the duty to provide a safe workplace when the employees are working outside of the workplace? In other words, when they're working from home.
Yeah, that's it. Okay, so let me do working from home, and then let's say potentially visiting a customer. But working from home, you're into that balance of safety, frankly, versus privacy. And so there are lots of things you can do consensually with your employees to maximize their ability to work from home safely. It might be something from the perspective of just providing them tools, right? You may end up sourcing for them everything from masks to gloves to cleanser, all the way through, not a health and safety issue, but a productivity issue, a large screen for their laptop as opposed to simply the laptop screen. But I think from working from home, you still have some obligations. They're balanced as against privacy. And when privacy comes in, most of us say it's a balance that says, take the least intrusive approach to achieve your objective. Your objective, keep them safe. So what you're not hearing me say is go out and buy keyboard surveillance equipment, right? Not those kind of things at all. But I do see employers in an educational manner and then a resource manner trying to help their employees from a work from home perspective. And we've seen everything from, from 9 to 12, you're taking care of the kids. You don't need the phone and the computer going. And in the job I need you to do, you can do that from 6 to 9 if you want. So there's a bit of a give and take in this area on the working from home. If you're going to go visit a customer, what I really suggest to all folks, customer or supplier, you want to engage with that customer or supplier to understand what in fact they are doing. Because there is a wide range out there with respect to compliance and health and safety approaches to this. And I really commend you to be proactively talking to where you're going to send your employee before they're simply asking questions as well. Because at the end of the day, you may get that same work refusal. I don't want to come from my home to work. I don't want to leave work and go to company A, B, or C. You want to be able to engage in a discussion about what you've already done to validate their safety.
Right. Okay. Thank you. Thank you very much. Okay, we're at 1 minute after 1 o'clock. I could keep asking you questions, and the questions will keep coming in here, but we're going to draw it to a close. So Michael Sherrod, thank you so much for joining us today, lending us some of your expertise and experience. In my opinion, your answers were not only grounded in good legal practice, but also in good common sense practice. And that's really important. So thank you very much. We have had questions about the availability of both the presentation and the recording from today, because you're anxious to share it with others. So we will have the recording up on YouTube and the presentation on our website before the end of the day today, so that you can go and take a look at them and share them as you see fit. That will only be possible due to the hard work of Carly Deslip, who is behind the scenes. She's behind the logo right now, and Carly is our administrator who makes all things technical happen for us. We appreciate her every day, and we appreciate, oh, there she is. We appreciate her in addition when we do special events like this, where sometimes the logistics can be a little complicated, and she makes sure that everything goes off seamlessly. Also Diane, who is Diane Cam on the screen right now, who works collaboratively with Carly and is our executive director, and provides her leadership when we're putting things together, like today's event. So today's event also came from the responses and the data that we received. Thank you to everyone who replied to our survey every week for 8 weeks. We appreciate it. We appreciate you sharing what was happening in your facilities and your companies as COVID hit us and then peaked. And, you know, we started working through getting ready to start ourselves back up again. You will be hearing from us. So we've taken a pause on the 1 week cadence of our surveys, but on June 7th, we will be sending out a new survey, but this time we promise we will only be sending it out monthly in June, July, and August. So we're hoping that everyone will take the opportunity to provide us with that information. We're using it to inform events like today where we can share information with you. We're also using it to inform all levels of government and our strategies going forward. So again, thank you to everyone. Mike Bilton wasn't able to join us again, but I'm sure he would echo my gratitude. Take care, everybody. And it's Thursday, so I can wish you a lovely weekend. Thank you.
Kelly, thanks for having me.